Yeah, the federal sentencing guidelines are at the forefront of any criminal case, from your initial evaluation of the case to assessing your odds at trial and making a risk benefit with your client. And then, of course, if your client is found guilty at the sentencing phase. But what they really are a series of guidelines or rules that the courts apply in federal cases, which primarily takes into two factors: the offense level that's assigned to the crime, meaning a higher number would correspond with what people believe to be, the Sentencing Commission believes to be a more serious offense. And the second significant factor would be the defendant's criminal history. On how many other occasions have they been convicted of crimes? But the federal sentencing guidelines have also changed in a real significant way over the last 10 years. And now there's something called the 3553 factors that the courts recognize, where we as attorneys can really bring to the attention almost anything that would be considered mitigating evidence that should be considered in the court sort of taking a holistic view of the defendant. But the reason why people place so much emphasis on the federal sentencing guidelines are the often very draconian penalties associated with federal crimes. You might have a client who's facing a mandatory minimum sentence of 10 years or 15 years or 20 years. Those are stiff sentences, and sometimes it might be up to life. So you have to be extremely confident in your attorney that they have the ability to take your case to trial, because sometimes you really don't have any choice. A client's often not going to take sitting down without a trial 10 or 15 or 20 years or up to a life sentence without going to trial. So the selection of a trial attorney who can take your case to trial at the federal level and win is of paramount importance.